Good afternoon. This is Glenda Bro, HFMA's Healthcare Financial Practice Associate. Welcome to this HFMA webinar, Understanding what the New Proposed Rules of the CFPB Means for You, sponsored by State Collection Service Incorporated. It is my pleasure to welcome today's speakers. Mike Frost is a partner at Malone Frost Martin PLLC. He is a recognized expert in legal issues for revenue cycle and receivables management, regulatory, compliance, and legal issues. He has nearly 20 years of experience in account receivable management industry, having held various leaderships and executive management roles. He brings a unique level of experience and understanding of operational and technical aspects of the receivables management process. He holds a Juris Doctor for the Drake University Law School and a member of Iowa State Bar Association. Leah Dempsey is the Vice President and Senior Counsel for Federal Advocacy, ACA International. She has a career marked by success as an advocate for financial services industry, committed to advancing their priorities at the Bureau of Consumer Financial Protection, the Federal Communications Commission, other federal agencies, and on Capitol Hill. In her role as Vice President and Senior Counsel for the Federal Advocacy at ACA International, Dempsey works to develop and implement ACA's federal advocacy agenda in Washington, D.C. She holds a Juris Doctor for the University of Baltimore School of Law and a Bachelor's of Art in Political Science, with a concentration in journalism for the University of Delaware. Dempsey is a member of the Maryland and District of Columbia bars. Stephen Beard is Chief Business Development Officer, State Collection Service Incorporated. He has an extensive revenue cycle experience working with many CFOs for the nation's largest healthcare providers, such as Mayo, CHW, ACA Partners, and UNC, to accelerate their revenue cycle performance. With that being said, Steve, I'll turn the presentation over to you.
My name is Steve Beard. I am with State Collection Service. For those of you that are not familiar with State, we have served the healthcare industry since 1949. In 2014, HFMA partnered with ACA International to create a task force of shareholders to establish best practices for a fair resolution of patients' medical bills. The stakeholders represented a diverse group of providers, including consumer advocates, collection agencies, and credit bureaus. We, State, participated as a member of that task force. So you may ask, well, what prompted the task force? Well, it was the Consumer Financial Protection Bureau, CFPB. The CFPB was formed in 2011 as a result of the Dodd-Frank Act. When initially formed, the CFPB's jurisdiction included banks, credit unions, security firms, payday lenders, mortgage servicing operations, and debt collectors. You'll notice that healthcare providers were not on the list of oversight. However, HFMA took the opportunity to take a proactive response and come up with that best practices template. At the 2014 HFMA A&I, Joe Fiver introduced the Medical Account Resolution Best Practices document. I checked, I Googled it, the best practices are on the website, and the recommendations of that Medical Debt Advisory Task Force are intended to improve the medical account resolution process for patients and providers alike. The best practices provide guidance on resolving financial obligations before, during, and after a patient's visit. An interesting note, in December of 2014, the CFPB issued a report on medical and non-medical collections, in which the HFMA's products, that best practices document, was cited throughout the report. So having said all that, it's important for us to understand the proposed rules of the CFPB, to understand where the agency is heading, and to ensure you, as providers, as well as your outsourced partners, are versed in the proposed rules. We're fortunate to have with us today 2 industry experts on this particular topic. So what we're going to walk through today are the proposed rules of the timeline, the impact on healthcare recoveries. There's some pros and there's some cons in here, and some of the proposed highlights. Well, before polling questions throughout this particular document. Mike, do you want to start us off?
Sure, would be happy to. Thank you, everyone, for the opportunity to speak with you on this topic today. The CFPB proposed rules are interesting, for especially the debt collection industry, but has an impact on creditors alike. So I think today's topics are really important for creditors as well as debt collectors to understand how these regulations could impact them either directly or indirectly. That said, if we could move to slide 5, I'm going to provide just kind of an overview of kind of what the CFPB proposed rules timelines are, and how that, for everybody to kind of understand exactly where we're at today and where we're headed in the future. The proposed rules were actually announced in the Federal Registry on May 7th of 2019. The public comment period closed September 18th of 2019. So at this point, all companies that would have actually identified some type of a response to provide to the CFPB had needed to submit that about a month ago. I think there was a very large number of responses, both from the creditor and the consumer bar side as well. So the CFPB has their work cut out for them to be going through. There are well over 1,000 comments, individual comments that were submitted. So they have their work to go through from a reasonable review perspective and go through all of those responses and understand what the issues at large are for each side. The CFPB does have an unlimited time period to review the public comments and make changes to proposed rules. So while we don't have a really good idea of exactly what that time frame is going to be, we do know they are going to take their time and walk through those. Our assumption is going to be anywhere between 3 and 6 months to actually get through all of those responses. And then they do have to perform what's called SBREFA panels. These are small business type panels to understand what the proposed rules could have as an impact on small business. We saw this in 2014 when they submitted the last round of proposed rules. They brought the SBREFA panels together, had those conversations after they had ample time to go through the responses that were submitted at that time. So we should see, I would say, I would guess, and this is a guess, there's no real science behind this, is really sometime at late Q2 to early summer that we will probably start to see some movement around the SBREFA panel area as the CFPB has kind of gone through these the responses to the rule. It's to finalize this process, the CFPB has to submit a final rule in the Federal Registry. So at some point after they get through the review period of all the proposed responses, they get through the SBREFA panels, then they'll have to post this rule. And then at that point, the agencies, which are directly governed by these rules, will have 1 year for implementation of all of the rules from the date that it's actually filed in the registry. Now, during that period of time, we could see lawsuits filed prior to or after the final rule is actually submitted. More than likely, you're going to have, from a jurisdictional standpoint, you're going to have lawsuits filed post-Federal Registry posting of the final rule. So we will be on the lookout for those. We'll get into a few of those areas that may be contentious, that may create litigation. Things for you to be considerate of, and understand what the position of HFMA and the members of this association may have with some of these proposed rules. If we can move on to the next slide. Understanding the role of the CFPB on healthcare recoveries. This is an important piece too, because you're really not, as your industry, you're not directly governed by these rules. So this is really focused on bad debt accounts. That's where the impact is, and that's where Dodd-Frank actually allows the CFPB. And Dodd-Frank's the underlying statute that created the CFPB. But Dodd-Frank actually provides what remedies and what capabilities the CFPB has in their rulemaking processes. This is not an early out revenue cycle. It's not, they won't be addressed in any of these rules directly, but you will see some of the impacts that it may have on you as a creditor, mostly from the standpoint of what it could do to recoveries and also information flow between the creditor and the debt collection agency. There are a lot of requirements that will require more information to the consumers at different times throughout this cycle. And we'll have to be very cognizant of those and starting to build things out earlier in stage rather than later. All of the bad debt agencies will need to adapt to the workflows and business rules in order to comply with these new regulations. Like I said, the biggest impact is going to be from a workflow information data flow between the creditor and the collection agency. We'll get into many of those things, most notably the G notice, which we will talk about in a little while. It's actually called the B3 form that's been provided by the CFPB. That form is really kind of your initial notice that gets sent out by a debt collection agency upon placement or upon contact with a consumer. So we'll get into that in a little bit. The healthcare businesses themselves may need to adapt some of the workflows that you have just based on how these new proposed rules may impact how the processes that you have in place. And one notable area that we'll get into in a little bit as well is around credit reporting. So there are new mandates that we'll get into the specific notification requirements that the CFPB has proposed in the rules, and talk about the viability of that as well. But if there is something to really be paying attention to, especially from a creditor's perspective, we're talking about the data flow, and credit reporting has got some major changes in this proposed rule. Again, the CFPB proposed rule it pertains to the Fair Debt Collection Practices Act. So it's not a direct element that governs the creditors. However, UDAP is always something to be cognizant of. The UDAP statutes, Unfair Deceptive Acts and Practices statute, does govern first-party collections. It does govern billing. So it is an area that, while the CFPB doesn't have the exact rules underneath UDAP that they have under FDCPA, and some of which we'll get into today, they do have authority underneath UDAP to be able to come in and identify interactions with consumers that may be inappropriate in their eyes. So while there's not a direct line of sight under the FDCPA, there may be a more direct line under UDAP. So we're going to get into some as I turn this over to Leah here in a second, we're going to get into call restrictions. We're going to talk a little bit about new forms of communication that we can work through, which actually are pretty good for us, understanding the electronic communication opportunities that the CFPB has outlined. We'll get into the e-sign Act. So there's requirements as we start to work into the electronic communication age in debt collection that we're going to have to really look at what these e-sign requirements are and how to comply with those under these new proposed rules. We'll get into some limited content message discussion, which is really talking mostly about how collection agencies are able to leave voicemail messages or not. And we've heard a lot about Fody versus Ortman, which are a couple of cases over the years that talk about what kind of messages you can or should leave for consumers when you are attempting to contact them. The other thing we'll touch on is, like we noted already, is credit reporting. And we'll get into a little bit of social media and some other pieces that we think are relevant to creditors and debt collectors alike. So I will turn it over to Leah.
To the next slide. Mike, just as a real quick, you had mentioned the electronic age relative to the Fair Debt Collection Practices Act. We actually have a poll, and it is when was the Fair Debt Collection Practices Act legislation passed? Okay, as we're moving on, we'll come back to that. Leah, did you want to go ahead and take the...
Sure, yes. Thank you guys so much for having me here this afternoon. And thank you very much to HFMA for the partnership with ACA and all your collaboration. ACA filed a comprehensive comment. It was 154 pages outlining our thoughts on the proposed rule. So my comments today are going to be based on those comments that we filed. So we're starting out with call restrictions. This is one of the aspects of the proposal that was very concerning to a lot of ACA members. And notably, many creditors also weighed in on this. If you look at the comment filings, a number of creditors expressed concern that the Bureau in a footnote mentioned that it may use its UDAP authority to impose call frequency requirements on first parties as well. So that's something that you might want to be aware of. So call caps are something that we've been anticipating really since the Bureau first started thinking about this rule many years ago. And I think it's something that both our industry and the Bureau have sought to collect data on. And as we outline extensively in our comments, we don't think that the Bureau really ever came up with sufficient empirical evidence to come to an exact number for a call cap. Alternatively, we outline extensively in our comments about some of the consumer harm that we think is probably more readily researchable and apparent that can result from arbitrary barriers to communication. Any kind of new regulation that can interfere with the ability to collect debt may actually increase debt collection litigation and impede access to services such as those offered by HFMA members. Additionally, in our comments, we outline that we think the Bureau exceeded the scope of its authority that Congress gave to them. In the FDCPA, there's prescriptions against harassment, annoyance, or abuse, and courts have time and again held that the number of calls placed in one day or throughout the week alone, no matter how frequent, cannot constitute Section 806.5 violation absent intent, because there are numerous reasons why a different number of calls may be placed. It really depends on the type of debt and the specific situation. So in our comment letter, we outline under Chevron analysis, which is the standard for how an agency can act, why we think they sort of overstepped the authority that Congress gave to them. And we argue that the new frequency limits depart from the clear statutory text of the FDCPA, which requires intent to annoy, harass, or abuse. So, we laid down that argument in our comment. We hope that it's persuasive to the Bureau, and it's certainly something that, if we ever had to, now that it's on the record, we could litigate on the issue.
I was just going to add real quickly that this is an area of the law that the debt collection industry took a hard stance on back in like the mid-2000s. There were a lot of cases that were filed against them on this intent to annoy, abuse, or harass, and there's a lot of good case law out there today. We know cases that allow up to 7 call attempts per day with voicemail messages being left. There's cases that allow 149 phone call attempts in 45 days. We're not suggesting that anybody wants to dial at that magnitude anymore, but I think what we're really trying to get at is the CFPB doesn't have the rulemaking authority under Dodd-Frank to generate new regulations. And based on the statutory definitions inside 1692 D5, which is this section of the FDCPA, they're not allowed to go in and circumvent an actual statement or word that's inside the legislation. And with this one, kind of what Leah was talking about is they can't overcome the intent section here by just putting a broad stroke or a broad-based call volume cap that doesn't have some type of methodology underneath intent. So that's really the argument that will probably come up, and I'd mentioned we may see litigation either pre or post final rule. This is one of those areas that I would expect to see some type of litigation around the CFPB's proposed rules based on the fact that they've arguably exceeded that authority underneath Dodd-Frank. So we'll have to wait to see how that plays out, but this is one of the areas to take a special look at.
Awesome. Now, Leah mentioned the Fair Debt Collection Practices Act on this slide. The poll results are in, and so 1968, 11% of you thought it was 1968. 1977, it was 28%. The leader was 1984 at 43%. And 1987 came in at 18%. So the actual answer is, Mike, do you want to tell the group? It was a great year. It was
sure.
Graduated high school.
The actual law was passed in 1977, and it was implemented in 1978.
There you go. 1977. All right, Leah.
Okay, thanks. Yeah, so I'll just, on the next slide, we're just talking a little bit about what this new frequency cap actually says. It basically creates a new violation and private right of action if an FDCPA covered debt collector exceeds the new cap. And as I mentioned, there's a question of whether it could apply to creditors through UDEP as well. So the specific requirement is no more than 7 times within 7 consecutive days, or within a period of 7 consecutive days after having had a telephone conversation with a person. So basically what that means is if you connect with someone and talk to them on the phone, you then cannot call them back for 7 days. So I'll just add a little bit of commentary on some of the things that we like in this proposal. We like the fact that there is a safe harbor if we do stick to the 7 calls, although I think Mike will probably want to get into that a little bit more about how safe we think that safe harbor is. And we also like that it's based on per account rather than per consumer. A sufficient number of consumers have multiple debts, sometimes even within the same agency. So we agree that this makes sense because different accounts can be being worked by different collectors, and changing this to per consumer rather than per account basis, we think could be extremely burdensome in new training costs, reprogramming, and a number of other burdens. As we note in this slide, there are also several examples of areas that do not count towards the call limit, and that's calls responding to a request for information, calls made with prior consent, and calls not connected to a dialed number. Also, calls permitted to third parties include consumers' attorneys, credit reporting agencies, creditor collection attorneys, or collectors' attorneys. One other issue I just wanted to touch on concerning the call cap that we expressed some concerns on is the fact that the analysis of it really doesn't take into account this new phenomenon that's going on in the marketplace with call blocking and labeling. I'm sure many of you receive robocalls, as they like to call them, on your cell phone, and over the last year this has really become a huge issue, I know, in Washington, D.C. and throughout the country. And as a result, there are all types of new call blocking and labeling apps, some better than others. And ACA members have been deeply affected by this. We did a survey of our membership last year, and well over 60% have had a lot of their calls being blocked. And we think that it's problematic that these new frequency requirements, in the research we have seen, don't necessarily take into account that the FCC has put in new rules in this area. Even as recently as this summer, they had a declaratory ruling that allowed carriers to have a default opt-out blocking, which means consumers don't even have to opt in to have their calls blocked. They have to opt out to have them not blocked. And we think over time this could really change the landscape of the number of live calls that are being completed. And we think it's problematic that the Bureau is moving forward with this cap without really fully considering how those technologies are playing into this. So on slide 11, oh, sorry, go ahead, Mike.
Yeah, I was just going to add to that because I think that we've seen already, even in the latest iOS download from Apple, that you can block it even further, a consumer can block it even further automatically, where they get a brand new phone and the only inbound calls that can be made to that phone are through those that identify or appear in your contacts list. So this gets really problematic from the standpoint that if somebody makes an outbound dial to a consumer that they have consent to call, and that number is not actually preloaded into their contacts list, it may get blocked from that perspective too. So to your point, this call blocking, call labeling is a huge issue as we're trying to find ways to communicate with consumers in the manner they want to be communicated with, but we're not able to based on some of these new products and features of cell phones, which is probably composed of 85% or higher of right party connects with a consumer in debt collection today. So it is a very problematic issue that we need to figure out, and I don't know that we figure that out through the CFPB proposed rules, but it's a sidebar type issue to be aware of.
Mm-hmm. Yeah, and just kind of jumping ahead to the next slide, one of the many ambiguities in the proposal that may need some additional clarification is that under the rule, there would be new restrictions on placing a telephone call, but there's not really a definition for what it means to place a telephone call. So I'll turn that over to you, Mike, to talk about some of the legal and compliance questions sort of looming there.
Sure. And, you know, when we talked about litigating a lot of these call line cases back in the mid-2000s, a lot of it got into the definitions under 1692 D5, which is listed here, and it talks about repeated or continuous. It talks about intent, and it talks about annoy, abuse, or harass. So when you get into litigation, you're really talking about breaking down statutes word by word and understanding what the legislative intent is behind that statute. Here, the CFPB actually took a different approach and didn't utilize the same verbiage that was used. They instead used placing or placed calls inside their proposed rules and didn't define that. So now we're going to be open to additional arguments from opposing counsel. I deal with them on a very regular basis, so we know that those types of issues are going to come. You know, and the one thing to really understand with this rule as well, I think Lee had talked about these safe harbors. We'll get into what safe harbors really are when we get into the notices. But there's one thing that does not include here is there's no litigation exemption. So regardless if there's a safe harbor or not, or regardless of whether this rule has the right wording or not, anything that an agency does that coincides with the CFPB proposed rule does not exempt you from litigation. So they're still subject to litigation from opposing counsel from the consumer bar, regardless of what the CFPB's safe harbors say, or regardless of what these proposed rules say. Even if they're a final rule, it's still not a litigation exemption. So we're still subject to the court's interpretations of all of the CFPB's input here. It's going to help. I mean, as we have these types of claims and we litigate them, we're going to have assistance by having these final rules in place, because we can hinge back on the interpretation of what the CFPB has identified under the FDCPA rules. But it's not a litigation exemption. So the agencies are still going to deal with litigation. The creditors, where you're seeing being involved in some of that litigation or being named in litigation, you're probably not going to see that continue. I don't know that it's going to be at more alarming rates, but you're not going to have that exemption, so we're probably going to see those continue. The big concern with this placing is, again, that it's not defined. So how do we set up our policies and procedures around the number of call attempts that we can make based on this proposed rule when we're not sure what placing is? And as this slide gets into, if you're familiar with ringless voicemail messages are provided to a consumer. They actually dial the voicemail. If you utilize your voicemail today on your cell phone, there's an icon that you can click on to go retrieve your voicemail message. That voicemail message is on a completely different platform. So you're not, when a ringless voicemail message is being dropped to a voicemail message, it should never ring the telephone. Yet the CFPB is identifying that as a call. Placing a telephone call would include the ringless voicemail messages. So that's where you can see that there's some ambiguity around this regulation, is what's really going to be defined as placing a call. When you're ringing a voicemail message which doesn't ring the phone, that's being considered a placed call under the statute. Where you leave a voicemail message, which we'll get into later, a voicemail message that's left by a debt collector on a voicemail machine for a consumer that is provided in a specific context is not going to be considered a call under the 7 call attempt cap. So that's where you get into this confusion of what actually is going to be considered a place call, what's going to not be considered a place call, and then how do you build those procedures around and those restrictions around your calling attempts to ensure that you're in compliance with these regs.
Good points. Yeah, another ambiguity that we just wanted to raise for you guys is the proposal states that a telephone call does not count towards the frequency cap if it is not connected to the dial number. But similarly, there's a number of ambiguities about what exactly this means, and as you can see on the slide, we note that the CFPB says a drop voicemail counts as a call, but I think Mike sort of described this before. There are all sorts of apps and technologies now that are sending calls directly to voicemail. I know Apple's doing it, Verizon in their call blocking technology is doing it. So it's not exactly clear if you call and you never, technically connect, how that's going to be considered in the frequency cap. A few other things that we raised is, a call that is routed to the consumer's voicemail box, but the voicemail box is full and no message can be left. Does that count towards the cap? And then just all kinds of different things that are arising with these new technologies. We think there's going to be some ambiguity in this area, and wherever there's ambiguity, particularly in our industry, it always leads to litigation. This slide, I talked a little bit about this already. As we mentioned, if you are in compliance with the frequency limit, you have a safe harbor, but I think Mike did a good job outlining of how that really protects you and how, there may be some exposure still in litigation through the courts. So I think we can jump ahead to the next one. So most listeners are probably aware that the collections industry is currently subject to a catch-22 when leaving voicemail messages. Basically, they have to identify that they are a debt collector, but if a third party overhears the voicemail with them saying that they are a debt collector, they can then be subject to litigation for disclosing that to a third party. So as Mike kind of talked about before, there's different case law in this area around the country, and some courts have approved certain messages that are sometimes called the mini Miranda. However, there's circuit splits throughout the country, and it's not exactly clear exactly what you can be saying on these voicemails. You're always leaving yourself exposed to some potential liability, no matter what you're doing, because of these circuit splits and because of the fact that the courts have just changed their mind on this several different times. So we think, if there's ever an area that is a clear area where the statute has not provided clarity and regulatory guidance is needed, this is it. So the CFPB has identified a proposed definition of what they are calling a limited content message that attempts to resolve both sides of the equation. It provides a method where debt collectors can leave a message for consumers and not risk violating the statute, which would reduce the number of calls a debt collector would be making to consumer. So we think it's actually not only is it helpful to the collections industry, it's also consumer friendly as well, because it's going to require fewer calls are being made and consumers are not going to be left wondering why someone did not leave a voicemail. So what it does is it defines a limited content message, allowing a collector to leave a message that would then not be considered a communication with the consumer as defined by the FDCPA. So there wouldn't be a mini Miranda required. And if it's heard or seen by a third party, it's not a prohibited third party disclosure under the FDCPA. I can tell you this isn't, oh sorry, go ahead.
Yeah, it might be good, and I can do this if you'd like, but it might be good to just kind of do an overview of Foley versus Ortman, because I think that helps you understand why a message should be considered or may be deemed a communication, why that's important in the courts.
Sure, yeah, you can go ahead and do that.
So if people aren't really familiar with this issue, and I'm just guessing by the number of people that didn't have the 1977 and 78 list there, that it may be good just to kind of walk through the Foley versus Ortman type messaging content. And early in probably mid-2000, we had a case called Foley versus NCO. It was in the Second District or Second Circuit, which is out in New York. I think that might have been actually the Eastern District of New York case. So a district court case came down. What agencies were doing back then is they were actually providing the name of the consumer. So they're trying to reach John Doe, whoever. So they would leave a message that would identify John Doe and ask them to contact the agency back. They weren't living the mini Miranda. They weren't doing a lot of that other stuff. This court case basically said, hey, you need to identify the consumer. You need to provide all the disclosures that are required under the FDCPA, and this is a communication. Leaving a voicemail message with a consumer is deemed a communication under the FDCPA. Now, that was very important. Deeming a communication under the FDCPA was important because you have to leave all those disclosures. If it's not deemed a communication, then all the disclosures, the mini Miranda, all the state specifics, anything that would apply within that given context is not required to be left on the voicemail message. Back in the day after FODI, ACA actually came out and helped all the agencies kind of figure out what a message would look like under a FODI message. The message took 52 seconds on average to leave. So you had to provide the name of the consumer, the name of the agent, the name of the agency, the callback numbers, the mini Miranda disclosure, all the disclosures that are required on that specific phone call based on where the call was at within the life cycle of the account. On average, those would take 52 seconds to leave. One, they're costly. Two, it tied up your phones where the agents weren't available for the next call, where they were leaving pre-recorded messages, which created a TCPA nightmare for everyone. So there were a lot of issues surrounding that whole FODI message. In early 2000, in this decade, there was a new court case that came out called Zortman. And it was more of a benign message that was left by an agency where they didn't provide the name of the consumer. They just said something to the effect of, hi, this is Mike Frost calling from State Collection Services, Inc. Please give me a call back at 1-800-555-5555. Thank you. And that was it. So it was just a very benign message that didn't really provide any information about whether the call was from a debt collector or anything like that. It just kind of gave the name of an agency, maybe the collection agent, and then moved on. Those actually took on average about 5 to 6 seconds to leave, and it's important to talk about that time frame on how long it takes to leave a message from an operational perspective. And a lot of that's based on billing from the underlying carriers and things of that nature. So when you think about all of that process, Zortman was identified as not a communication by every circuit in the United States with the exception of the 11th. So the 11th Circuit in Hart versus Credit Control, which was a case I think in 2014 or 15 right in that area, in Hart versus Credit Control, the 11th Circuit came out and said, whether it's a Zortman or a FODI message, they're all going to be deemed a communication under the FDCPA in the circuit. So most agencies are not leaving FODI or Zortman messages at all in the 11th Circuit and a few other states just based on some of their rules. Instead, they're leaving, or not leaving the messages, so they're not identified as a communication of the FDCPA. Otherwise, you have to provide all those disclosures. So that's kind of the history behind this problem. That's why the CFPB is so focused on this limited content message. And that's why, as we see, as Leah continues to go through this, why they came up with what they did come up with, but we'll kind of poke some holes into, from a legal perspective and how we litigate these cases in the future, why it may or may not make sense.
Thanks, Mike.
Before we move on, Leah, before we move on to this next slide on required content, we actually have another poll question. And the poll question is, do you require your agency to make a specific number of call attempts within a specific period of time? Either a yes, no. All right, the results are in. It looks, well, they're still coming in, but it looks like there's about 33% is yes, and about 66% is no. Good information.
Well, just one other point I wanted to touch on before moving on to the required content is that this is an issue that's gotten a lot of pushback from consumer groups, citing privacy concerns about leaving these limited content messages. There was actually a sign-on letter in Congress circulating about 2 or 3 weeks ago from Democrats in the House Financial Services Committee, where a number of them opposed this aspect of the CFPB rule, saying that it would, introduce privacy concerns. And we think that really that doesn't make a lot of sense. Even notwithstanding all the legalese and the case law and all that kind of stuff, it also, if you just kind of think about this from a common sense point of view, since 1977, voicemails have changed a lot too. I don't think that many people probably have a family answering machine anymore where you're sharing these voicemails with, all the people in your household. I think most people are probably getting these on their cell phone, and they have the, very easy control of either playing it out loud or listening to it in the privacy of their own time. So I think that some of what you're seeing in the press and some of what you're seeing on Capitol Hill talking about how this is opening the floodgates to exposing that people owe debt is really, out of all the things that we think some of the pushback doesn't make sense. I think this one is one of the most clear examples of people not necessarily understanding the situation and the problem. So some of the required content of what will be in the limited content message, it will be the consumer's name, a request that the consumer reply to the message, the name or names of one or more natural persons whom the consumer can contact to reply to the debt collector, a telephone number that the consumer can use to reply to the debt collector, and if applicable, the disclosure required. And as I said before, we fully support the limited content message. We think it's one of the most helpful aspects of the CFPB's proposal, but ACA in our comments did outline a few areas where we think some additional clarity may be helpful. One thing that we said is that we think it should be allowed for electronic contacts as well. We suggest that an email address, text message, number, or other yet unknown type of communication method should also be available in addition to the phone number, particularly when it's delivered in writing. We also said that communications via email should be included because consumers have expressed that they can be convenient, and we think it makes sense for this as well. We also urge the Bureau to provide some more consideration to issues such as telephone disconnection, carrier issues, or hang-ups for technology that may prohibit you from leaving parts of the voicemail. We could see litigation occurring if you were attempting to leave the limited content message, but because of a technological issue beyond your control, you weren't able to leave the whole message. We think it'd be helpful if the CFPB would provide some commentary around that. And as currently proposed, the limited content message is a message that says the consumer's name was one of the things that was in there. However, it doesn't specify whether that means first name, both first and last name, only last name. So that's something we think might be helpful for them to provide some clarity on in their commentary. And one last thing is it does say a lot of those in the collections industry will often use aliases. And it does say that aliases are okay, but it doesn't really clarify exactly how that connects to whether a specific alias has to be connected to one natural person, or as is currently the practice in some agencies today, they'll sometimes associate one specific alias with a specific letter that they're using, and then when the consumer calls, they know to connect the person that deals with those types of letters to them. So that could throw a wrench in those types of things. So we asked them to consider being flexible in that area, knowing that not every employee is in the agency every day from 9 to 5. It may be helpful to have a little bit of flexibility in when you're leaving a name and connecting to one exact person. So those were some of the areas we thought might be helpful. Mike, do you have any additional thoughts on any of those things?
No, the bigger concern goes back to kind of the question of whether it's a communication or not a communication. And just thinking about this and what we've talked about with call blocking as well is when you're trying to place a call to a consumer, and that's the terminology that the CFPB is using, how is that considered in this limited content message perspective? And also how you leave that message could change the scope and dynamic of how that word's defined. But utilizing placed on a call attempt and then identifying those blocked calls, is that considered a placed call or not, since it never got through and it was blocked? So there's just a lot of questions around both limited content message and the call volume area.
Mm-hmm. Yeah, and you know, adding some more ambiguity into this, they also include in the proposal some optional content that you can include, and that is a salutation, the date and time of the message, a generic statement that the message relates to an account, and suggested dates and times for consumers to reply. You know, I think it's helpful that they put this in there, but I think, especially with the safe harbors, it's not clear how this optional content will come into play with the safe harbors. And really, you know, since right now it's in this category, I don't know how helpful this specific aspect of it is. But that's something we also asked for some additional clarity on. And just sort of jumping ahead to the next slide, you can see an example of the limited content message. There it is on your screen. And as you know, as you can see, I think this kind of makes my point again about, you know, the sort of inflated privacy concerns. As you can see here, this is not a ton of information about someone's debt that's going to be left in this message. And in fact, a lot of our members are concerned that doesn't allow you to leave the creditor's name in there. They actually have some concerns that this may not even be enough information to elicit a callback. So I think that, you know, the Bureau probably struck a pretty good balance of balancing privacy with the concerns of the industry, because there certainly isn't, it's certainly not opening the floodgates here to letting everyone in the world know about your debt through these limited content messages. Before I turn it over to Mike, just one last thing I wanted to mention is that this is another area where we think consumer groups may try to litigate some of these issues. I know that they've argued that the Bureau exceeded their authority by putting this limited content message in the rule. In our comment, we did a Chevron analysis actually supporting the Bureau's legal authority to do the limited content message. So this is another area where we spent some time laying out the legal parameters in case we have to go to litigation on this later on. Turn it over to you, Mike.
Okay, sounds good. So we'll shift gears. If we didn't identify enough confusion within those two areas, let's provide some more.
Hey, Mike, do you mind if I
go ahead.
A polling question? And it is really in the face of a 501R, how many of you require your agencies to credit report? Okay, the answer is about 63% said I don't know, and then it's a tie between yes and no, the remainders. Go ahead, Mike.
Okay. So credit reporting is an area that does cause concern, and we touched on it briefly before, but this slide actually gives you the statute number and what it actually states under the proposed rules. The debt collector must not furnish to a CRA, credit reporting agency, information regarding debt before communicating with consumer about the debt. So the question really is a lot of agencies and how this can impact them and their recoveries is based on what's known as the letter at RPC, or letter upon contact. And when I utilize the term or the abbreviations RPC, that's right party contact. So some agencies and some portfolios will actually work with their creditors where they don't send the initial notice out to the consumer upon placement. They send the initial notice out upon contact. And the question here is that even a viable option anymore after this new rule, if it actually survives? Because the one thing that has been communicated to the CFPB and one area, again, that I think could spark some litigation is this area, the FCRA nor the FDCPA have this requirement in it today. So the CFPB's limited ability under Dodd-Frank, which is more than what we've seen in other regulatory bodies, they do have rulemaking authority. But rulemaking authority is not defined as drafting new legislation. It's creating rules around an existing statute to provide clarity and provide understanding on how to implement that type of a rule. Here, there's not a rule that they're revising. It's a new rule. So today, there's no requirement of the FDCPA or FCRA for an agency to provide notice to a consumer prior to credit reporting. There are 2 state statutes that do require it. The state of California and Utah both have statutes on their in their legislature that basically identifies this requirement that CFPB is trying to put in place. So I think this is going to be another one that gets contested. Is it a requirement for the CFPB to be able to provide that type of new regulation, and then what impact really does it have on us in the revenue cycle management process on credit reporting? And I think the vast majority of creditors in the medical space are having if they are credit reporting, they are going to have their agency do the reporting for them. And if that's the case, how does that coincide through this process? And is that going to happen upon placement and having letters sent out or text messages sent or email sent to provide that initial communication with a notice that the account will be credit reported? The problem that we're seeing in the courts today, too, and this is the biggest area that I have concern with most of the CFPB proposed rules, it doesn't take into account the active litigation that's out there as much. Maybe it did, and maybe they're trying to identify kind of a safe harbor for us to follow in this perspective. But when you look at the current case law that's out there today, there's a lot of cases that we're seeing in this industry on credit reporting notifications within the validation notice. So it's an overshadowing argument. And the argument basically is the consumer, or least sophisticated consumer, which is the standard that we are upheld to as debt collectors, is the least sophisticated consumer confused by the fact that the account could report, and would that reporting happen within that first 30 days of the validation period that's provided? So do they have to dispute within that 30-day period first? And does the credit reporting notification that's been provided to them suggest anything that could overshadow that validation notice? So we're seeing a lot of cases in that area today. Having to furnish this before communicating with the consumer about the debt is really, it's not saying, hey, you have to communicate before you report. It's saying before you're communicating about the debt, so you really have to put it in that initial notice. Well, then we're up against this issue again in the courts. What does that mean? Are these cases that we're seeing today, premised on this new issue that the opposing counsel is seeing in the proposed rules, or how is this going to be implemented? Further, you have a later time frame on credit reporting due to 501R. So any nonprofit hospitals have to wait a period of time much longer than a for-profit hospital to report anything to the credit bureau. With that being the case, then you have to consider that validation notice and the information that's contained in that, and how you provide that notification to the consumer, or if there's a different way to provide it. Moving on to the model validation notice, this is something that we thought was really important and something to take a close look at. If you can expand this, if you have the availability of this presentation after our presentation. If not, you can go right to the CFPB's website and click on the debt collection rulemaking process, and inside there you're going to actually see this model notice. And it's in a PDF format, so you can download it and really take a close look at it. The interesting thing about this model notice is that there's a different format that the CFPB is attempting to communicate with consumers on. Today, most agencies provide the name of the agency at the top. They identify, the creditor, the balance that's owed, and the account number. And then they provide a series of disclosures that are required. And they'll also provide a remit slip at the bottom that identifies how the consumer may pay the account and where they need to send, a dispute or anything to. How they've revised this in the CFPB proposed rules is they've modified the language that currently is used by the debt collection industry in the validation notice, and that language comes directly out of the statute. So they've modified all of this to put it into layman's terms so consumers can read this and understand it, which is good in premise, but again, there's no litigation exemption, so every agency that modifies or utilizes this safe harbor type model notice is still subject to litigation. And with that modification, where it's not verbatim from the statute, what's that mean? Did we give enough of the validation information? Hopefully it flies and the courts are going to accept it, but we just don't know today. But taking a look at this, there's a couple of areas that are really problematic and things to hone in as from a creditor's perspective. If you look at where it says our information shows, it says you had a Main Street Department Store credit card from Bank of Rockville with an account number of 123-456-7889. Below that, it says, as of January 2nd, 2017, you owe $2,234.56. Between January 2, 2017 and today, you were charged this amount in interest, which they've listed $75. You were charged this amount in fees of $25. You paid or were credited this amount towards the debt, $50. And then the total amount of the debt now owing, which is $2,284.56. We're very accustomed as debt collectors in receiving the balance due or the balance provided and then providing breakdowns as needed. So while this doesn't sound overly problematic, the area that is problematic and information that we're not getting or debt collectors are not getting today in their file layouts from the creditors is this: you paid or were credited this amount toward the debt. So normally you would have the field that would provide the amount due. So what's the balance on the account? That's the amount that would come over. Now we're going to have to know what the actual amount was due at inception. So how much was actually charged to the consumer up front? How much did they pay during that time frame? What's now owed and due and owing? And also what interest and fees were added to that, if anything. Obviously, that is going to create a need for us to look at what data sets are being provided from the creditors to the debt collectors to understand what needs to be modified for the debt collectors to be able to comply with these regulations. The other thing that's alarming with this model notice is you can see there's that one section that talks about their debt under our information shows, and that only goes down a couple of sentences. If you look at the entire right side of the model notice, the headings speak for themselves. How can you dispute the debt? What else can you do except pay? And then back in the remit, it also says something similar. How do you want to respond? So not only here's your rights to be able to dispute, but how do you want to respond? Do you want to respond to dispute the debt because you think it's not your debt, the amount is wrong, or other, please describe? And they can just check a box and then send this back into the debt collection agencies. So it's almost, suggesting to the consumer that if you don't have a response or a dispute, do you want to have a dispute? And if you do want to have a dispute, here's some dispute options. So we're probably going to see an immense number of dispute increases after these rules go in place as people try to comply with this regulation, and probably fewer payments based off these initial notices that get sent out. Leah, did you have anything to add to that area?
No, I guess we can move on in the interest of time. I know we're kind of...
Another area that's kind of important here and has to do with the validation notice is really trying to figure out the itemization date. So when we're requesting itemizations of debts back to the creditor as debt collectors, what does that mean? And there's been some confusion around that. Is it the last statement date for the specific account? Is it charge-off date? Is it a last payment date, or is it transaction date? So the CFPB has basically said you can use any of these for that itemization time frame. So when debt collectors are requesting validation of the debt, these are the areas that we need to look at to be able to identify how do we provide sufficient validation to comply with the statute from that perspective. The question that kind of surrounds this too is how will this impact the calculation of the statute of limitations? So there's a lot of question around statute of limitations today. What's an out-of-stat debt? Excuse me. And how do you calculate those statute of limitations periods? So we'll have to take a close look at this as this unfolds too to understand, is the itemization of debt, if it's used for the validation purposes, will that need to be used for statute of limitations calculations as well? So updating consumer communications. This is an area that's actually pretty exciting. So we talked about a lot of the gloom and doom already, the things that we think are going to have some impact, either positive or negative, under these proposed rules to debt collectors. But really looking at some of the goals of creditors today, and specifically the healthcare systems, there's a customer or consumer experience that you're always looking for. So we're trying to find ways as healthcare providers and downstream as the billing agents, how do you improve the consumer experience with the hospital? And they're going to be an ongoing consumer experience here, so that's important to us. So we look at this and understand, first and foremost, is that a third of the current workforce today are millennials. And a third of consumers that are in debt today, a third of the debtors population that we're receiving account placements for, debt collectors are receiving those account placements for, are millennials. Millennials grew up in the age of electronics. They want to speak in the omni-channel. That's the new technical term, or kind of a buzzword they hear in the industry today, is omni-channel communications, which really includes everything that's electronic, whether it's chat, text, email, social media sites, things of that nature. Those are the formats in which consumers want to converse. We know through research that consumers in that group are really focused on being able to communicate, not so much, they really want the electronic formats, but they also want to communicate at the time frames that they want to. So they want to be able to call in so much more than being called. So that's a lot of the, as you're looking through this and trying to understand what is that consumer experience and how do you improve that, part of that's starting with who are the vast majority of people that are utilizing these systems, who are the consumers that are in your portals, and who are those, how do we conform to what their needs are? And really it's providing options. That's really what it boils down to, is the patients that want to engage in this format, because there's many that don't. Especially in the baby boomer area. My parents absolutely, they still use flip phones because they don't want to deal with the smartphones. So how do you communicate with that level of patient, and what's that experience to them as well?
So having said all that, our final polling question is, based on your admitting documents or patient consent, do you obtain electronic communication? Many of you have addressed TCPA through cell phones, but do you also go through and add text and email communication? Mike, there's some really good news here. The vast majority, right now 82%, are saying yes, they do obtain consent for text and email.
Music to my ears. That's great.
So just kind of adding on to Mike's point, the FDCPA, as we learned earlier in the presentation, was enacted in 1977, and it actually references telegrams rather than email or text messaging or any of the forms of communication that are most widely used today. So we were very happy that the proposal, at the very least, acknowledges the use of email and text messaging. It tries to bring us up to date from 1977. However, as we'll go through these, there's some pretty complex requirements to be able to use both email and text messaging. Right now, only about 15% of ACA members are using email, and the reason for this is due to some of the litigation concerns, primarily about liability for third-party disclosures, among other things. So the proposal would identify some safe harbors for those communicating via email and text messaging, and it provides two methods for which debt collectors could choose for placing required disclosures in an electronic communication. As we have up here on the slide, the first method is it would place the disclosure in the body of an email. The second would be to place the disclosure on a secure website that is accessible by clicking on a hyperlink, include it within an electronic communication, provided certain other conditions are met. One thing to note about the hyperlink issue is there has been some recent litigation in the Seventh Circuit that I think is calling into question how the Bureau can proceed in this area, and whether there may be some additional concerns about using hyperlinks. I don't know, Mike, if you want to talk a little bit about the Med1 case and just some of the concerns there.
Yeah, real high level, and I'll try to keep this short because I know we're kind of running low on time here. But Lively versus Med1, the Med1 was the collection agent, and they sent a notice via email to the consumer. In the body of the email, they had very little detailed information due to the fact that they were trying to prescribe against third-party disclosure. So they basically had a hyperlink that had the content of the actual message on a website that the consumer had to go and log into and then identify whether that the disclosures and all the stuff that was supposed to be provided in that initial communication was provided through that link. The court looked at this and said, you know, there was no communication as defined under the FDCPA, and we got into the definition of communication earlier in our discussion, and it really focuses around when you're required as a debt collector to provide a disclosure, you need that to be identified as a communication. And here the court said it's not a communication because you sent the consumer a link to go retrieve a communication. You didn't send them the communication. So one way that agencies have been complying with this, there was two kind of trains of thought. One train of thought was to provide this hyperlink to get them into a secure portal so there's no third-party disclosure. The other theory is to provide an encrypted PDF so the consumer would actually have the PDF in the communication. Most times they just use the zip code of the consumer, so they would type that zip code into the encryption portion or password to allow them to open the PDF attached document. In that situation, the communication is actually delivered because it's delivered no differently than a piece of mail would in snail mail. So there's a lot of, it's interesting that the CFPB came out with this proposal and is authorizing the use of hyperlinks when there's a court case at the Seventh Circuit level that, and actually I think that Seventh Circuit level decision came out after the CFPB proposed rules. And prior to that, at the district court level, that was already in place for the last couple of years. So I think looking at this, you go, okay, now what's the question that we have to deal with? Again, back to the point that we don't have a litigation exemption. We're going to get sued in this context if we put a hyperlink in an email or a text message, if it's going to be providing all the required disclosures and communication under the FDCPA. If it's a benign message, that may be different. But under a full communication of the FDCPA, in order to get credit for delivering that initial notice and validation information, you're going to have a communication with the consumer. You're probably not going to be able to use a hyperlink to do that based on the current case law. So it puts us again at odds of what the courts are saying versus what the regulatory agencies are saying.
Thanks. Yeah, and just jumping ahead to some of the other additional requirements. So collectors providing disclosures must do so under the rule in several different ways. And as you can see, as outlined on the slide, you have to identify in an email subject line or first line of text the current creditor name plus one additional piece of information identifying the debt. You have to monitor the receipt of undeliverable notifications. So that basically means you have to have a system in place to monitor bounce back emails. And for validation notice sent after initial communication, provide notice in responsive format reasonably expected to be accessible on screen of any commercially available size and via commercially available screen readers. I'll just talk about two of those areas that ACA members have raised some concern about. I think the bounce back requirement could be a problem to have, specific procedures in place that are going to effectively capture all the bounce backs that you get. I know I personally you never know what's going to happen with bounce back emails. Sometimes you get them right away. Sometimes you get them a few hours later. I think that's a little bit onerous and complex to have a system in place that would be able to do that. Also, these commercially available size and commercially available screen readers, not knowing exactly, how this will turn out. I can tell you as someone who worked previously in the credit union industry who was facing a lot of litigation under the Americans Disabilities Act for website accessibility. There was a lot of litigation on that issue of whether people could effectively access websites. I could see something like that coming into play with these, with this new requirement. So those are just, two other areas to be aware of and to be thinking about as we move forward in implementing the rule. Next slide, please. So this just talks a little bit about some of the additional requirements. So a debt collector must maintain procedures reasonably adapted to avoid a bona fide error. And these kind of outline some of the procedures. The creditor or debt collector would need to notify the consumer clearly and conspicuously that they might use a specific non-work email address. or specific non-work telephone number, the creditor or the debt collector would need to provide the notice no more than 30 days before they engage in any communication by email or text messaging. And the notice would need to identify the legal name of the collector and the non-work email address or non-work telephone number. I'll just touch quickly on the fact that this issue of differentiating between work email and non-work email is a pretty significant concern of ours. Right now, there's really not a vendor that does this, and a lot of people that work for themselves or work from home, they may be using emails for multiple purposes, and there's really not a clear way to differentiate why someone is making the personal choice to use whatever email they use. So this is something we spent a lot of time in our comment on outlining why we think it could be problematic. I can tell you for the requirement of giving 30 days notice, we thought that was a little bit tight of a time frame. We asked them to extend that to 45 days. And as we talk a little bit, as we also talk about on this slide, we can jump ahead. It looks like we're jumping ahead to the next slide. Jumping ahead to the next slide, again, complying with all these different requirements can earn you a safe harbor, which we support. But as we sort of outlined, there's some fairly complicated aspects of these disclosures that certainly we hope the Bureau will consider some of our feedback and maybe make some changes before it becomes final. And otherwise, we know that some of the agencies, it may take some time and resources to come into compliance as is. But I'll turn it over to Mike now.
So I'm going to touch real quickly on opt-outs and electronic communication. So I might skip through a little bit of this just in the need of time. But opt-outs, any communication that's done in an electronic format is going to have some type of an opt-out metric. We're used to that today in emails. We all see the opt-out options. So it's going to have to be built out similar to that. We're going to have that in text messaging too. So whether it's an opt-out link, and then you get into the arguments of does a link work, I think it does in the context of an opt-out, probably not in the context of providing a communication under FDCPA. But in an opt-out, you could do it by link. You could do it by accepting text back that say stop, things of that nature. So that we can't. Also, it has to be an opt-out that there's no fee attached to it. So those are pretty common requirements and probably not too difficult to deal with on the electronic communication. Next slide. I'm going to skip through this one. This one we talked a little bit about the validation notice and the initial communication, the impact on letters RPC, so we can skip that one. The next slide really talks about e-validation and the notice responses. The big piece or the big takeaway from what I've seen over the next couple of slides is really complying with the Electronic Signatures Act. So the e-Sign Act, which most people refer to this as, the CFPB basically identifies this as a requirement for continued communications with a consumer through an electronic format. So in the event that a collection agency receives consent from a consumer through the creditor, so the creditor at one point, like we talked about earlier, I think 83% of you are all providing some type of a consent authorization form at intake, at patient intake, which is great. So that patient intake, you get the information that's consent. You're able to transfer that to the collection agency. The CFPB is giving us an opportunity in that first communication with the consumer where the consumer would normally communicate with a creditor or his authorized communication with a creditor. They're allowing the debt collector to make that outbound communication with the consumer in electronic format, but we also will have to obtain electronic signatures at that time. So I've provided some language a couple slides back here. It would be on, I think, 31 and 32, where you can look to see what you have today in your current web portals, consumer portals, or your intake forms to make sure that you're getting e-signed consent, that we can pass that e-signed consent to the collection agencies. Now, there's an argument that the collection agency is going to have to get their own e-signed consent, which means they're just going to have to figure out a way to obtain e-sign through emails or through text messaging. Today, believe it or not, you can get e-signed consent through the phone. So there are applications. The CFPB came out in 2015 with a bulletin on e-sign and talked about recurring debit card transactions, which collection agencies take. And when they do that, they're required to get an e-sign authorization form from the consumer. You can actually use touch-tone keys and symbols to generate a consumer electronic signature. So agencies can actually employ that technology that's available and hopefully gets extrapolated to text messaging and email, where we can obtain information or e-sign consent from the consumers directly through text. Email is going to be a little bit more difficult. I think text messages are about 20 times more effective response rates than what you get from electronic mail communications. So trying to get a consumer to respond to an e-signature authorization through an email is probably going to be a little bit more difficult than a text, but still may create some obstacles. The big thing is to know that you're going to be mandated, or the agencies are going to be mandated to get that electronic signature. The creditors, from a UDAP perspective, should be looking at that as well. So what steps could you take today to start complying with this regulation? We can skip another slide, if we could. One more. So those last few slides really talk about what mandates are required to be able to be provided in the disclosure. What I've provided here is actually documentation from the e-sign Act, where you can put in your portal today. So if you have a payment portal or you have in your patient intake forms, if you take this language and drop it in there and have the consumers check the box on the portals, or put a signature or initial block here on the e-sign notice disclosure in that initial intake form, then you're capturing e-sign consent for the consumer. So this is another area that we're going to have to find a way to be able to transition this information from the creditor to the collection agency, and it should be something that the creditors are looking at in maintaining compliance with UDAP specifically for their agencies going forward. So if there's a takeaway to be considering, it's take a look at this slide and talk to your legal today about what modifications do we need to make as creditors to identify the e-sign consent from the consumer, and can we do that at patient intake? This will be important ongoing for you to maintain that that communication option for consumers in that electronic medium. So I think we've kind of we're actually a couple minutes over. This last couple slides is really going to walk you through the electronic disclosure flowchart. So this talks about how you can capture e-sign consent, and it has an option and then a proposed alternative. This is also available on the CFPB's website. So if you go into the website, click on the debt collection rules, they actually have this PDF document. We could send this out to the group if we wanted to, if you prefer to do it that way as well. But you take a nice hard look at this as well to understand what e-sign requirements are going to be imposed on collection agencies and the creditors in the future. Because I do believe you're going to see more of this e-sign litigation ensuing both at the creditor and the collection agency level, whether these rules get implemented or not. We can skip this one too and get to the last slide here. And really, Leah?
Yeah, I can just talk about this real briefly. Under the new proposal, they do address social media, which again, we're happy that they're acknowledging the way people are communicating today. It does say that you cannot communicate on a public forum. So essentially, you continue to not be able to write on someone's Facebook wall or somewhere that's a public forum to communicate about a debt. And I can tell you, I don't think many or really any ACA members are communicating that way today. So we, in the proposal, supported that aspect of it. However, we're happy that there is an exception for private social media. So if you're sending someone a message in something like Facebook Messenger or LinkedIn, where it's a private message, that's okay. And we are glad that they addressed that in the rule. They do have an aspect in there that says you cannot communicate with any person other than the person described. So one minor concern that we raised is that it's beyond a collector's control whether somebody else has access to someone's social media private account. So we asked for some additional clarification in that area in the commentary when they finalized the rule. But overall, we think that that was a good step forward and appreciate the fact that they acknowledged that you can use private messaging services in that area. You know, lastly, I think overall we probably scared you here with all the lawyer talk and all the complexity associated with the rule. But really, overall, I think it's going to be a good step forward for both of our industries, and particularly in acknowledging the use of new technologies that people are communicating with. So hopeful that as the Bureau works to finalize this rule, they consider some of our feedback, and we think that if they do, consumers will be even better off when they can effectively, when our industry can effectively use those technologies to communicate with them, because that's the way that they've asked to be communicated with. And, you know, as Mike outlined, millennials don't answer a lot of phone calls. They're not looking for snail mail letters. They're looking for emails and text messages. And it's really to their benefit to be aware of their debts and their account information. And if they learn about things sooner and can work to more quickly resolve them, I think all consumers will actually benefit from that and have more access to services and credit in the future.
Thank you all for that engaging presentation. If you have any questions, please enter them in the Q&A box located on your computer screen. You do have time for a couple of questions. I do have one that's in the queue. It says, what is the healthcare entity reports its own debts to the credit bureaus? Is the healthcare entity required to send notification to the consumer prior to reporting?
This is Mike, and I can take that one. It's a great question, and the answer to that is no, you're not, because you're not subject to Dodd-Frank, and you're not subject to direct requirements under the Fair Debt Collection Practices Act, which is the rule that they're actually providing, or that's the legislation that they're providing the rule under. So directly responsible for, no, you would not have to send out notification prior to it, except for actually in 2 states you'll want to take a look at to understand if it's actually applicable to the creditor or not, is in California and in Utah, which I believe it is, but it'd be good for your legal to take a look at it to ensure that if you are credit reporting in those 2 states that there's a state mandate to provide notice prior to any collection attempts. So take a look at those 2 states, but under this CFPB proposed rules, it would not apply to you directly as a creditor.
Okay, we have time for one more question, and that is, would an email or text message be required to comply with the HIPAA regulations as well?
So under the medical rules, the medium in which you communicate would not change your requirements to comply with HIPAA. So I think the same regulations would apply whatever format or medium that you're attempting to communicate with the consumer at. While that seems daunting at first task, it's not as daunting as I think you may feel it is. So while not a lot of debt collectors are actually communicating by email today or text message, some are. So there are some options out there that for agencies working in the medical industry to be able to provide encrypted PDFs that have all the information that would be considered HIPAA governed or governed by HIPAA. So there are areas there that we'll have to consider in how we communicate that, but most of them should be accounted for in that encryption format.
Thank you. Do either of you have any closing remarks?
I would just say thank you so much for the time today. It's been very fun to go through this rule. I wish we would have had a little bit more time to talk about e-sign, so make sure that your legal take a look at how that impacts you. But really, thank you again for the time today. We appreciate the opportunity to walk through this rule with you.
Yeah, I would just add to that, thank you everyone for your time and to HFMA. And if anyone has any questions for me or Mike, feel free to email or give us a call anytime.
We have reached the conclusion of today's webinar presentation. I would like to thank our speakers for presenting and State Collection Services for sponsoring this very timely presentation. If you have further questions about this webinar, you may email them to HFMA's Resource Center at resourcecenter@hfma.org. Our Resource Center staff will assist with questions not answered during this webinar. Thank you for your participation and have a great day.